Thank you. Thanks very much for having me, especially thanks to Russell for inviting me here today. I missed this morning's events because I was giving a lecture in Canberra, and I am going to have to leave after questions to get back to Canberra. So I hope it was a fascinating day, the bits that I didn't hear except for Tony's. Okay, what we have here are some examples of scams in the news. So we have someone in Nevada in a sort of employment benefits scam involving $4.4 million US. He received a sentence of 37 months, so just over 3 years in a federal prison, and he was ordered to share with 3 other defendants in the restitution of paying back that amount of money. Then in the UK, we have a team of criminals. They made off with £2 million through fraudulent accident management companies, and they got sentences of over 12 years imprisonment, lengthy sentences. Again, another US case, although this one involved although this involved a much larger amount than the UK one, ended up in a comparable sentence, 11 years imprisonment for a Houston doctor who was involved in a healthcare fraud conspiracy, and again an American one with an accountant. So you're seeing a lot of white collar offenders in this area, which is probably not news to any of you. So these were just some of the examples I saw when I searched, just using Google, very rough search of sentence and scam. And there was a piece in the Herald last year that highlighted that scams are the hardest security threat to protect against because they rely on exploiting naivety rather than technical flaws. And I think you're probably aware of the ramifications of that. Here on the domestic front, we recently had a Sydney accountant, Regina Subramanian, who stole $45 million from ING, where she worked, for over 5 years. So it's not much comfort to any of you who, like me, have had money with ING. And then she went on this sort of amazing shopping spree where she bought jewellery and sort of Moët Chandon and $8 million property, and which even in Sydney does get you quite a lot, and designer clothing, kind of went crazy. And then ultimately they only managed to recover $16 million of it. In sort of effecting this fraud, she made 200 illegal transfers into her personal accounts or directly to the shops and real estate agents with whom she was doing business, and then used the computer logins of former staff at ING to delete the records or change them so that transactions seemed to be legitimate. But her lawyer argued that even though her conduct was obviously deceptive, that this wasn't a particularly sophisticated fraud. The fact that she got away with it for so long suggests that it was sophisticated enough for long enough. She pleaded guilty, and in February this year she was sentenced to 15 years jail. It's a very high sentence here in Australia, with a non-parole period of 7 years. And this was reduced because the judge in the case, Judge Michael Finane of the New South Wales District Court, accepted that she needed counselling and that she'd been abused by her grandfather as a child, which left her with a personality disorder. And as we'll see when I go through the sentencing factors, these personal factors are a big part of how judges and magistrates in the local courts arrive at their sentencing decision. His Honour also accepted she'd become involved in an abusive relationship with a supervisor at her company, which contributed towards a sense of resentment and desire for revenge. So sort of the motivation there was taken into account. And when he sentenced her, Judge Finane noted that she never used the items and properties, and her offending was therefore not motivated by greed, nor did she in fact use the money to pay off her mortgage or other debts. So it was somehow kind of illogical that she offended as she did, and that seemed to assist her somewhat when it came to sentencing, but she nevertheless got a very severe sentence. Now, when I was doing the preparation for this, I was helped with getting some information from Russell and other people at the AIC in terms of the order of magnitude of what we're dealing with here. So in the most recent members update for this Australasian Consumer Fraud Task Force from September last year, the ACCC received 8,016 scam-related contacts with reported financial losses of over 9.6 million. although this fell steadily throughout October to December when there were 6,230 contacts with losses of around 5.5 million. You probably understand better than I do as to why we're on a downward trajectory. It's not a bad thing. But I'm now going to look at what happens when you get through all the investigation stuff, through the prosecution stuff, bearing in mind that obviously there are challenges along the way, and what I'm dealing here with sentencing is sort of, the pointy end of it. Most cases will probably fall out of the system earlier on. But I just want to give you a quick sort of run through of what sentencing officers take into account, what's the sort of the law and the logic that goes on sort of behind the mystique of sentencing. So I'll be looking at the purposes of punishment, the principles of sentencing, relevant sentencing factors, and sentencing dispositions or options. So, in the seminal High Court case of V number 2, a majority of the High Court, Chief Justice Mason, Justices Brennan, Dawson and Toohey, and this was a murder manslaughter case, they said the purposes of criminal punishment are various: protection of society, deterrence of the offender and of others who might be tempted to offend, retribution and reform. The purposes overlap and none can be considered in isolation from the others when determining what is an appropriate sentence in a particular case. They are guideposts to the appropriate sentence, but sometimes they point in different directions. So what do these purposes mean, and how do they relate to fraud matters? So the first is retribution, and this is at the heart of what we think of when we think of punishment. It's based on the belief that those who engage in criminal activity deserve to suffer. And one of the oldest versions of this is in the Old Testament's eye for an eye, or lex talionis principle. But in its modern incarnation, the punishment has to fit the crime. We don't go out lynching people. And so it's to be proportionate to the gravity of the offence and the offender's culpability. I would say that the significance in this context is that the loss which may be suffered through some large-scale scams may be significant, but generally white-collar offenders, as we know, which I'm not saying all scammers are, but obviously many are, have been traditionally dealt with pretty leniently by the criminal justice system. So getting the measure of retribution right is one of the challenges. The next purpose is deterrence, and I think you heard a little bit from Alice Hutchings this morning about that. So there's two kinds of deterrence, general and specific. General deterrence aims to deter others from committing the crime committed by the offender, and it certainly assumes a significant role in relation to fraud matters. But critics argue that it's unfair to punish one person by reference to a hypothetical crime of another, and also that would-be offenders are not necessarily rational beings who conduct a cost-benefit analysis of their conduct. Now, you heard about rational choice theory this morning. The argument falls down probably more in relation to crimes of passion and violence offences which are carried out in the heat of the moment, and maybe not so much in this context. Another argument against deterrence is that offenders think they won't be caught or are unaware of the likely punishment for their crime. So general deterrence, I think, has a pretty important role to play here in terms of making an example of the person who's currently before the courts. The criminal action in many scams is well planned and carefully executed. And the financial motivation which underpins what are often very sophisticated businesses refutes that notion that would-be offenders don't act rationally. I would say it's probably not fanciful to think that if you had operators of a bogus work-at-home scheme sent to prison, others might learn of that and be deterred from operating a similar scheme. Specific deterrence aims to prevent offenders from committing the individual offender from committing further offences by demonstrating to them the adverse consequences of their acts. It's of less significance where the offender is regarded as being unlikely to reoffend. It can be difficult to test the effectiveness of this because there are, of course, many factors that impact on someone's likelihood of reoffending. Certainly some studies in the general context have shown that harsher penalties have limited effects in terms of specific deterrence. But there's again still a place for specific deterrence in this context, because otherwise the penalty might simply be regarded as the cost of doing business, and that it's then sort of reabsorbed as part of the illicit operation. There's a 2009 case by the Western Australian Court of Appeal, Nickaganry and Western Australia, which involved a sentence appeal in relation to an advance fee fraud. And there the appeal court found that the repetition of the offending demonstrates that significant weight had to be given to the need for personal deterrence in addition to general deterrence. So courts certainly do invoke this when it comes to sentencing offenders in this context. And you also heard from Tony that deterrence was a factor in the Van Halteren case. Then we have the issue of rehabilitation. And the core premise here is that by dealing with the reasons for an offender's criminal behaviour, so sending them to drug treatment or anger management or something, you can then help them re-enter society as useful members of the community. And so when I was thinking about how this would apply here, I was thinking many fraudsters actually demonstrate significant business acumen and technological nous and entrepreneurship, and these are actually useful things if they could be harnessed in a pro-social sort of a way, and then society as a whole will benefit. And so I recall a program I'd read about some years ago called the Prison Entrepreneurship Program, which was developed in Texas, where the program links executives, so legitimate business owners and managers, with prisoners through a program of entrepreneurial education and mentoring, and then it engages business and academic talent to redirect inmates' energies in a constructive way, which will enable them to productively re-enter society. In 2007, it was reported that in the first 3 years of the program, its graduates had a return to prison rate of 3.7% compared with a national average of 50%. So that's a fairly promising outcome. And by July 2010, which are the most recent figures available, over 90% of the 600 graduates had been legitimately employed within 3 months of their release from prison, and there'd been 75 new businesses started. So that's where rehabilitation may have, or that's an example of how rehabilitation may have a role to play here. Another purpose of punishment is protecting the public, generally by means of incapacitating offenders. Now, when we think of incapacitation, mostly we think about jail, but it can also mean incapacitating them in relation to the way that the offence was committed. So, for example, it could mean licence disqualification or curfews and electronic tracking devices which keep them at home. Or, as I'll come back to later, restrictions on access to computers. So that may be a form of giving some weight to the purpose of incapacitation. And finally, we have denunciation, which is based on the theory that a sentence can be a means of communicating not only to the offender, but to the community, the message not to contravene the law. It's relied on as a means of expressing disapproval. And one of the particular aspects in this context is that many victims in these scams are, in some respects, somewhat complicit in the criminal activity. I mean, if it sounds too good to be true, it probably is, but we all want that Nigerian scam to give us the extra $2 million. So there may be some scope for courts to think about how expressing denunciation for the offender's conduct may or may not translate through into denunciation for victims and society at large, and what the implications of that might be. Now, separate from these purposes of punishment, which, as you heard, are these sort of guideposts in different directions, are the principles of sentencing, which are the legal rules that courts apply when sentencing an individual offender. So, you know, we don't just have the grand theories at the top. This is what comes into play each and every time they sentence someone. So first we have the proportionality principle, which requires courts to impose sentences which bear a proportionate relationship to the criminal conduct in question. This principle operates to prevent the imposition of sentences which are manifestly excessive, but also sentences that are manifestly lenient. So it operates at both ends of the spectrum. The Australian Law Reform Commission has suggested that the principle is the primary mechanism for ensuring that sentences imposed on offenders are fair. And it's been suggested that the principle reflects common sense and intuitive notions of justice, as well as preserving the legitimacy of the sentencing system and giving practical guidance to judicial officers. It could be argued that as scams become more extensive and sophisticated, judicial officers may come to see lenient sentences as disproportionate to the gravity of the offence, especially when they take into account the number of victims and the amount of the loss suffered. As Smith, Urbis and Grabowski noted when writing about cybercriminals, cybercrimes raise new concerns about proportionality, as the consequences of some types of offending can be great and yet the conduct itself involves no physical violence. So clearly we need to ensure that the sentences for, say, a superannuation scam are proportionate when compared with a burglary, which might involve more immediate violation of the victim but have much less financial impact. Then we have the parsimony principle, which operates to prevent the imposition of a sentence that is more severe than that necessary to achieve the purpose or purposes of the sentence. Obviously this has some overlap with the proportionality principle, but it is different. And a specific example of this is the notion that imprisonment is only to be imposed as a sentence of last resort. And that's set out in the legislation in most Australian jurisdictions. Clearly, as you can imagine, courts will be more willing to impose a parsimonious sentence on a scammer when they see rehabilitation as the main goal than where the objective is deterrence. So you can see how these principles sort of interact with the different purposes. We then have the totality principle, which applies when an offender is sentenced for multiple offences, and this will often happen in this context, or where they're already serving an earlier sentence. And it seeks to ensure that the total sentence the offender receives is an appropriate one. The thing to know about this, though, is, so the High Court has said, this makes sure that the offender doesn't receive a crushing sentence. But the thing is, it gives a discount to someone who's a pretty active offender. So you won't get twice as long a sentence if 200 people fall for your scam than you would if 100 people fell for it. So it's a difficult issue to come to grips with. In America, they do it differently. You hear of 200 and 300 year sentences, they just add them all up. But in Australia, we don't have that principle. And because the sentence for incrementally more offences and more victims get incrementally smaller, it can sometimes mean that victims feel that their offence didn't really count for anything. So that can be something of a challenge. We then have the consistency principle. So consistency in sentencing is regarded as fundamental to a fair and equitable criminal justice system. And basically it means that two offenders who've committed similar crimes and have similar circumstances are going to receive a similar sentence. In and of itself, that's not particularly controversial. The parity principle, which is seen as a subset of that, requires offenders who have jointly engaged in the same type of criminal conduct to generally receive similar sentences, although the courts can take into account different levels of culpability and the offender's individual circumstances. So this has particular relevance in relation to multiple co-offenders participating in the same scam. And finally, we have individual justice. So Acting Chief Justice Marnie said in Cable, if justice is not individual, it is nothing. So, when you've weighed all the other issues into account, judicial officers need to ensure that the sentence is appropriate in all the circumstances of the case that they're dealing with. And they also need to have enough discretion to consider all the facts, as well as enough sentencing options to tailor their sentence to the offender's individual circumstances. Now, when it comes to sentencing factors, that is what an individual judge or magistrate takes into account, research has shown that there are up to 300 factors that influence sentencing courts. And factors will generally be aggravating or mitigating, but some of them could be either depending on the circumstances. Now, before looking at the general law in relation to sentencing factors in Australia, the UK Sentencing Guidelines Council recently handed down guidelines for sentencing and statutory fraud offences. And I thought it would be worth having a look at these to see how they've typified it for that context. And then you'll see when we go through the Australian factors that there's a lot of overlap with the general position. So the council said that the primary consideration when sentencing fraud offences is the seriousness of the offending behaviour, and suggested that in determining the seriousness of an offence, the offender's culpability and the harm should be determined by the following. So we have the impact of the offence on the victim, and that can include non-monetary impacts. So if the object of the fraud was of particular sentimental value, that would be taken into account. Harm to people other than the direct victim, so secondary victims. The erosion of public confidence. This is perhaps particularly significant in relation to banking scams, government frauds, things like that, where the general public assumes that these will be legitimate businesses. Any physical harm or risk of harm to the victim or others. The difference between the loss intended and the actual loss that resulted, and any legitimate entitlement to any of the money obtained. So that's as a consideration of the seriousness. They then set out some specific aggravating factors. So where an offence is carefully planned, where there's a high level of profit, if there's an attempt made to conceal or dispose of evidence, where there's deliberate targeting of vulnerable victims, so particularly the elderly, I can imagine, where there were multiple victims, where there was a breach of trust, where the offending is carried out over a significant period of time, and where it involves the use of another person's identity. And it's generally recognised that a form of identity theft will cause particular distress to a victim. On the other hand, the following will be mitigating factors: mental illness or disability, where the offender played only a minor role in the fraud, circumstances where the behaviour wasn't actually fraudulent at the outset, so if the offender originally had a legitimate claim to the money, or where the offender was involved on the basis of some kind of misleading information. So if they'd been deceived by someone else and then they participated in the fraud. Voluntary cessation of offending, and they think in particular about how long it's been since the offender last offended. I mean, if you were carrying out 2 weekly scams and it's only been 10 days and you say, I stopped of my own volition, it might count for less than if there'd been 2 weekly scams and they voluntarily desisted 12 months ago. Voluntary restitution, and the financial pressures that the offender was subject to. So I'll come back to some of this in the Australian context, but the financial circumstances of the offender and what motivated them into it will also be relevant. So in Australia, we generally group our sentencing factors as follows. First, we think of factors that are relevant to the offence. And these factors are principally concerned with the nature and the seriousness of the offence. One of the key ways this is determined is by the legislative view of gravity. So that is the maximum penalty laid down by the legislation. So clearly an offence which carries a maximum penalty of 20 years will be viewed as more serious than one that carries a maximum penalty of 2 years. And you saw in Tony's presentation that there were amendments in New South Wales recently that doubled the maximum penalty for certain fraud offences from 5 years to 10 years. So that's a very clear way of the legislature sending a message to the judiciary saying, this is serious, take it seriously. Another important consideration is breach of trust, and that's going to be of particular relevance in relation to banking, health, investment scams, government scams, things like that. The intention and consequences are also relevant. So it may be aggravating that the consequences of a scam involved significant financial damage to an individual. But on the other hand, where there was relatively little financial damage, or where the offender did not foresee the extent of the damage, for example, if the scam went much further than they were expecting, that may limit their liability. Now, motive is irrelevant to criminal responsibility, but it is relevant to sentencing. So if someone becomes involved in a scam not to get rich, but out of some kind of necessity, for example, they've got to pay for medicine for their sick family member or something, or if they were forced into it by their co-offender, that may be a mitigating factor. On the other hand, where scams are motivated by pure greed, that will be aggravating. The method, so how the offence is committed, is also relevant. So the extent of sophistication involved in planning it and executing the offence, which was part of what the Sentencing Guidelines Council in the UK was talking about as well. And that might, in this context, mean someone who carries out, say, a sophisticated scam which imitates a legitimate government or corporate website or logo would be sentenced more harshly than someone who has a more amateurish approach to effecting the scam. Also relevant is a degree of participation. So the ringleader will generally receive a more severe sentence than someone who's just a minor player in it, although this is still subject at times. You still have the issue of the parity principle, and so courts need to weigh up whether they really were carrying out similar roles. The difficult thing here is that it can sometimes be difficult to work out who did what and what their role will be. And unsurprisingly, many offenders will try to exculpate themselves while inculpating their co-offenders. The victim is also a relevant consideration, so firstly in relation to their vulnerability, but also their response to the offence. So if you have a victim who's particularly forgiving, this can be a relevant consideration. But the courts have also said that sentencing shouldn't be influenced by a particularly punitive victim. As you can see, these are things that, the two sides of the coin can be difficult to reconcile at times. And the impact on the victim may also be relevant, so if they suffer long-term financial or other harm. And finally, the prevalence of an offence might be relevant. So if a particular offence has been increasing over a period of time or in a particular area, that can be taken into account. But it can be difficult to accurately determine prevalence, especially with scams that are perpetrated across national and international borders. And as you saw in the Northern Territory case of Sweeney and O'Brien, the absence of evidence in relation to both of those factors, the impact on the victim and the prevalence was taken into account by the court, or was noted by the court. Then we have the factors relevant to the offender. And don't worry, I'm not doing all 300, this is a brief overview. So previous convictions is regarded as, one of the most important factors in sentencing. An offender's prior criminal record is expressly stated as a relevant factor in most Australian sentencing legislation. Linked to this issue is good character. So it can be a significant mitigating factor where the offender has done significant volunteer work in their community or otherwise has a good reputation. In this context, some white-collar offenders will be able to draw on unblemished characters and a lack of prior record to mitigate their sentence. So there was a 1990s case, Warren Bund, where he defrauded more than 2.3 million from a business consortium as part of a Nigerian scam, but he was described as being a highly respected businessman and a devout member of Adelaide's Jewish community. So, upstanding members of the community committing these frauds get a bit of an advantage relative to, someone who might go and burgle a house but has a long list of priors. An offender's age is a relevant consideration. Offender's mental or physical health will also be relevant. So in the case of Zahir's 1998 Victorian Court of Appeal case where the offender used 41 false birth certificates to engage in various state and federal frauds, the offender's poor health was taken into account. Other relevant considerations will be personal crises, so if an offender had a particularly traumatic upbringing, and you saw that in the Subramaniam case in relation to the fact that she was assaulted by her grandfather and then developed this personality disorder, and substance abuse issues. And there's a somewhat complicated body of law in relation to whether it merely explains the offending or is some kind of mitigating factor. And likewise, gambling addiction is probably quite important in this context. It's also emerging as a relevant factor, but it will generally only be it will only offer mitigating weight, but it can be a bit of an explanation of why the offender offended as they did. Then we have the response to the charges. So this is the offender's behaviour after the offence. Firstly, as you're probably all aware, pleading guilty is a very important mitigating factor. But the weight that's given to this will vary depending on when the plea is entered and the strength of the prosecution case. Now, I imagine that many consumer fraud cases would be very complex to prosecute, as we know. To investigate, they would involve a large number of victims and significant paperwork around what financial transactions took place when. So there may be a large discount for early pleas on the basis of their utilitarian value in terms of reducing costs and delays to the system. Another factor here which is linked to a guilty plea but different is the issue of remorse or contrition. So there was media commentary over whether Bernie Madoff felt remorseful for masterminding a $65 billion Ponzi scheme for which he received an $150-year sentence of imprisonment. Generally, expressions of remorse will carry greater weight when they're accompanied by some kind of action, for example, apologies to the victim. Restitution or reparation are also mitigating factors, but it's generally argued that an offender should not be able to bargain with the court or buy their way out of sentences. And that's particularly apposite here, where scammers may amass considerable wealth from their crimes. On the other hand, as the Sentencing Council has noted in the UK, providing an incentive to return property or money is particularly important, as it may be difficult for a victim to recover his or her losses in any other way. And as with a guilty plea, the timing of that restitution will be important. And finally, we have the issue of cooperation and assistance to law enforcement authorities, especially when coupled with a guilty plea. This can attract discounts of up to 55% on the sentence. And as we saw in the UK example, volunteering offences that authorities otherwise wouldn't be aware of can carry significant weight, as does giving evidence against co-offenders, so that having one person report on their co-offenders is hugely important, and that will result in a discount. And then we also have some factors that go around the effect of the offence and the sanction on others. So it may be a mitigating factor where the offenders suffered some kind of extracurrial punishment. So they've public exposure or loss of position or status or income. So if someone in a position of power is dismissed from their position once the fraud's discovered, possibly even before it's been fully investigated, that will be taken into account. It's sometimes controversial because, again, it will advantage middle-class offenders. And it's particularly relevant in the context of offenders who have sort of hidden behind this mask of respectability in order to be able to carry out their crimes. Now, you'd be aware of some of these sentencing options, so I won't go into too much detail. So first we have unsupervised orders. These can be non-monetary orders, so release, discharge, dismissals and bonds, either conditional or unconditional, and they're generally more minor cases, or monetary orders such as fines, and some of the fines imposed in relation to scams can be in the tens of millions of dollars. Then there are supervised orders such as community service and probation orders. There's generally a fairly low cap on the number of hours that can be done, so this is again going to only apply to the more minor scams. The substitutional orders of imprisonment are formally sentences of imprisonment, but they're not served in a custodial facility, and the main ones are suspended sentences, home detention and intensive correction orders. The advantage of these sentences are that the offender can remain in employment, which can may enable them to make a valuable contribution to society, including possibly continuing to make money, which they can then pay back to their victims. But on the other hand, well-off offenders will suffer a relatively more lenient penalty than offenders who live in less palatial surroundings. So again, this will benefit a white-collar offender. So in last year, the Australian reported that white-collar criminals are escaping jail terms after new laws were introduced in New South Wales, scrapping weekend detention and instead allowing convicted criminals the freedom to live at home, work and enjoy their usual social life with friends and family. So we might have questions about how well that is serving some of the other purposes of punishment. Obviously, we're all aware of imprisonment, and internationally some offenders have received very high sentences, including ones that go beyond the term of most people's natural lives, and here we have the 15-year Subramanian sentence. Now, there's also these ancillary orders, which are made at the time of sentencing but don't operate as standalone orders. They can include orders for restitution, compensation or forfeiture, which are a means of recouping the stolen funds, as well as goods used in the commission of the crime. And they can be quite significant in scope. So in an American case last year, an offender was ordered to pay $30 million in restitution, as well as receiving a prison term. The Australian Law Reform Commission says that ancillary orders are generally not seen as having a punitive purpose, but in work that Russell did, he suggested that these orders do seek to punish offenders by removing from them something of value, which in the case of high-tech criminals is the ability to use the computers and the internet, and I'll come to that in a second. The reality is, whether you see them as punitive or not punitive, they can also have a significant role to play. So what I wanted to look at is just this one example of restricting the use of computers as a sanction and how that might apply in this context and what some of the issues are around that. So this could be made either as an ancillary order, or it could be a condition of a probation order or a home detention order, or it can be a condition of a parole order following prison. So there are a number of ways that this could be added to the level of punishment, I'll suggest punishment, that an offender experiences. In 2004, Russell analysed 29 cases from the US, 1 from Canada and 3 from Australia, where courts imposed these forfeiture or restriction of use orders in relation to computers, and found 1/3 of the cases were not challenged on appeal, 1/3 were successfully challenged on appeal, and the final third were challenged but affirmed on appeal. So already then the courts were starting to, accept that this might be, the appellate courts were starting to accept that this might be a reasonable way to go. Although there were concerns in America, where the majority of the cases came from, that this sort of order might infringe constitutionally protected freedom of speech, which obviously we don't have anywhere near as much of here. Smith argued that orders of this nature would be appropriate where reasonably linked to the purposes underlying the order, so deterrence, incapacitation, things we've talked about, and involve no greater deprivation of liberty than necessary, so not breach the parsimony principle, and also not be overly broad. But we also need to balance this against the fact that computers are so widespread now in daily use, and offenders might use them in a range of ways that would promote their rehabilitation. So if restricting access to a computer would prevent an offender from being gainfully employed, this will impede their rehabilitation. And that may in turn then have an impact on their ability to make restitution for their crime. So there's this sort of longer flow-on effects. Also, the potential impact on others has to be considered. So in a 2001 Queensland case, it was found that ordering the forfeiture of a computer on which the offender had accessed child pornography would have been detrimental to the offender's children. So this could be seen as a violation of the proportionality principle. There might also be issues of enforceability. So offenders could use other people's computers to circumvent the intention of the order. So it could go to an internet cafe, go to a library and get access to a computer in other ways. And there is obviously this issue of others having a legitimate and unrestricted right to use the same computer. So it would be difficult to enforce if there is the computer in the home, who's used it at what time. Finally, although increasingly sophisticated monitoring or filtering software might be employed, many scammers will probably be more technologically adept than the people investigating them. So again, there's going to be issues in relation to enforceability. At the other end of the spectrum, Russell suggested that offenders could be ordered to use their technological know-how in a constructive way. So this could be by performing some kind of community service which builds on their expertise, or ordering them to deliver cautionary warnings about fraud to would-be offenders and or victims. Quite how judicial officers would craft and enforce these orders in scamming cases remains to be seen, but it's something we might see more of in the future. So what I've tried to do here is give you a bit of a crash course in sentencing law with a focus on how this might apply in relation to consumer fraud cases. I say that we are in some respects at the dawn of a new era in relation to high-tech crime, and I think there's significant scope for thinking creatively about how to sentence scammers, but this has to be against the backdrop of an understanding of the purposes and principles of punishment, the aggravating and mitigating factors taken into account by courts, and the sentencing options available to them. Thank you.
Any questions for Lorana?
Yes.